Good afternoon, everybody. Welcome to another episode of the Wednesday webinar with Property Law Alliance. The reason I'm speaking like this today, because we're influenced by Harry and Meghan Markle with the whole royal debacle. We're not just property lawyer, we also throw in one or two things here that's happening in the media.
Well, I must say, I don't think I've seen this. There's a debacle. I don't even know what the debacle is all about. If we had time, I would have loved to have been enlightened in all of that. I'm sorry, I'm that loser that didn't even have time to, follow royal drama this week.
I've got no idea what's happening. I see highlights about people speaking up and the Queen being disappointed and the guys from Suits supporting her. I've got no idea why they're supporting her. I don't know what she's done.
So there is a legal element to it. Is that what you're saying? Suits are involved. So definitely.
Oh, Chris, let's be fair. If Harvey Specter is anywhere, it's law.
So I'll tell you what.
Why don't we have him as a guest next week? Let's arrange.
Yeah, I'll just
everybody
call him
in
up.
the comments. Yeah. Let me know if we need to get Harvey Specter.
I'll tell you what they're actually arguing about, and that's our next question. It is, when do I need to pay transfer duty? When do I pay VAT? Silna, please can you help us and the royals out in this question?
Well, I think if you have to sell Buckingham Palace, or what's that other castle? Windsor Castle. Look at me now. I clearly watched all the seasons of The Crown. But so if you have to sell that, definitely you're going to have to make a call whether you sell it as a going concern to a second monarchy, or if you are selling it as just a building. And I think that's sort of the answer. I'm so glad we're talking about VAT and transfer duty, because during our conversation last week around installment sale agreements, somewhere, and I think if this at least comes as some form of comfort for all our viewers, even at our very best, as known experts in our fields, we sometimes mix stuff up. And I personally made a really interesting little confusion last week in last week's discussion about installment sale agreements. And I gave the most amazing rules around sale of a going concern while we were talking about installment sale agreement. So it happens actually quite often that you sell a property as a going concern, and very often, especially when it comes to farmland, the decision very often lies between an installment sale agreement or a going concern. And that's exactly where things went completely belly up for me. And I will blame this one on the color of my hair for the moment. But actually, I think it's just the things are so closely intertwined. And an installment sale agreement can very often be one of the things that you consider when buying a farm or an expensive piece of land. I mean, it doesn't have, there is no monetary limit or threshold or something for an installment sale agreement, but very often a farm or a business, so business land, industrial property. This is typically the properties that we see installment sale agreements being used on. But one of your other options is a going concern. So I am so happy about this question, Chris. Thank you so much. I can redeem myself. And a going concerns rules are, it has to be, both parties will have to be VAT registered, and both parties will have to trade in this entity. So you have a trading entity. So let's use a farm as an example. So there's a farm. You have millies or whatever there's tractors, 5 chickens, and maybe a cow if you're lucky. Cows are expensive. Maybe a cow. And the farm is trading. The farm is registered in a company or in a CC, so a juristic entity of sorts. It's VAT registered. The purchaser buys that entire going concern the purchaser will also have to be VAT registered. And if that is the case and all the boxes are ticked, you sell the property as a going concern, which will then be a zero-rated transaction. What that means is, because both parties are VAT registered, for the one party it's input VAT, for the other party it's output VAT, and it ends up on a zero effect, so there will be no taxes payable. However, when you transfer, and Bruno, I'll throw the transfer duty of Windsor Castle to you, but transfer duty is something else, but you will never ever pay both transfer duty and VAT. It's either transfer duty or VAT, or in certain circumstances, as in the case of a going concern, sale of a going concern, where both parties are VAT registered, you have a zero-rated transaction. Now, I just want to caution our viewers on this, because like I said, as much as the blonde amongst us sometimes get confused with these things, make sure when we talk about tax that we don't get clever. And what I mean by clever is sort of hiding figures in documentation. Transfer duty can run into enormous figures. And if you are unable to sell the property as a going concern, so it's not a zero-rated transaction, and you have to then pay transfer duty, or for that matter, VAT, if it's not a going concern, it could be really proper high thousands of rands that we are talking about. People want to avoid this. And what people very often do is they do believe that they can reduce the purchase price in terms of the offer to purchase, and then have a deal on the side to repay the rest. I want to say it politely, but I think I'm rather going to call the spade the spade. That is tax evasion. And tax evasion is bad. And unless you can pull it off in orange, I would rather avoid it. I don't look pretty in orange. I won't even lie. I can't even try wearing orange. But some people can. And if you can, cool, you can do that. But unfortunately, to reduce your purchase price in terms of your OTP, but the money still flows at a higher rate, intentionally misleading SARS to believe you sold for a lower price, so with the pure intention to pay less taxes, that's tax evasion, and that is bad. So when you want to avoid the VAT and the transfer duty elements, consider a going concern. But to the point of installment sale agreements, again, remember, even though you're only going to transfer later, your transfer duty, which I'll pass the ball to you just now, Bruno, is payable within 6 months of conclusion of the installment sale agreement. So bear this in mind, because it might feel like it's a 5-year from now problem, but it is very often, no, not very often, it's never only a 5-year from now problem. You're going to end up with penalties and interest, and we all know how good SARS are on penalty and interest.
Bruno, my dear boy.
Scare us more.
Do you think the Queen is VAT registered?
I don't think so. That's why I said, no, that's why I said you must explain the transfer duty on Windsor Castle. And do you think there's another monarchy that would buy the royal family's stuff as a going concern? I don't know. From what Chris is saying tonight, I wouldn't want that.
It's on a very side note. I remember reading an article once where they were speaking about the monarchy and all the land and funds that they have. And it started off as a criticism where people are like, well, they've just got so much. It's insane. They shouldn't own that much. But they're the largest, if I'm not mistaken, I stand to be corrected, but they're the largest landowner or private landowner or something along those lines. And the income generated from those assets, including some of the businesses. And if I'm not mistaken, they pay taxes on that, or they give money back to the government. So the government gives them a subsidy, but then they actually create money, and the government receives benefits from that. And the amount that the government gets from the things that they own and they run is actually massive. So they were just looking at the numbers and saying they're not actually that bad when compared to private businesses through all the income generated. So it's just interesting, but like complete side note, no relevancy tonight.
It's an interesting side note, though, especially on property law, because I mean, imagine the before times when monarchies were running the world. They obviously owned basically the majority of the land. So if that wasn't transferred or something later, it makes a lot of sense. Which would mean why they are that extremely filthy rich. Which, to our viewers, this is why you should own property.
Nice.
Then you are as true as
because the queen does. So to go back on the question, like, no one can blame you, still not, because I've got a transaction where something similar happened, and you can feel that because all the concepts and principles, especially as we're drafting and coming up with plans for clients, everything just starts like merging together and the water becomes muddy. And I'll actually talk about the case just so you guys get a general idea on how this thing was structured. But maybe just to start off from the beginning. So when selling a property, like Silna mentioned, either transfer duty is payable or VAT is payable. VAT would only be payable if the seller is VAT registered. If the purchaser isn't VAT registered, the VAT would still be payable if the seller is VAT registered, and transfer duty is payable in all other circumstances, right? So we used to find really, really terrible examples of this in auctions and sales and execution, where you've got stupid clauses that say transfer duty is payable unless VAT is payable, in which case it's not included in the purchase price, so the purchaser needs to pay it above and beyond the purchase price. So they used to do that all the time, because now remember, you as a purchaser pay transfer duty. Typically, in terms of the contract, your liabilities to pay transfer duty. So the property is worth R1 million. You're going to pay the R1 million, and then on top of that, you'll pay the transfer duty. Now, if the seller's VAT registered, right, and the purchase price is deemed to include VAT, as it normally is, because most prices out there in the market include VAT. I mean, you go to Pick n Pay, they tell you it's 50 Rand, it's 50 Rand. They don't throw VAT on top of it later. So if the property is worth R1 million and you say R1 million, and it turns out that they're VAT registered, generally speaking, the seller would have to pay the VAT. So that would come out of the R1 million. So the purchase price in the seller's pocket is now less the VAT component of that, right? So what they used to do, and maybe this is the first aspect of the answer, be careful, guys. There's huge red flags that come up. Read that VAT clause and transfer duty clause very carefully, because if it says there, oh, by the way, if it turns out that the seller's VAT registered, the purchase price is not deemed to be inclusive of VAT, and that will be payable by you, because you'll find that VAT at certain levels is higher than transfer duty. So you do not want to be the person paying VAT as opposed to paying transfer duty. So be very, very careful with that. But now, at least now you understand the difference. So transfer duty is a normal just transfer of property. VAT typically has to do with when the supplier, the VAT vendor, is selling one of the supplies under his business, right? So that's now where we start coming in. So zero rating transactions is kind of flowing from this concept, because now the VAT vendor is selling something that's VATable. And if it's a going concern and the person buying it happens to be VAT registered too, then for all intents and purposes, no VAT is payable, because they set each other off, and SARS considers this as zero rating. And this is great, because now it doesn't exclude VAT and make transfer duty payable. It just says that VAT is zero. So now you get the benefit of not paying transfer duty at all. And now this is something to consider, because there's a lot of cost savings sometimes when it comes to this. So the transaction we were working on was the sale of a commercial property. Everyone was worried about, oh, but it doesn't fall within the Alienation of Land Act, like we discussed last week, because it's not a residential property. So how do we do this? And it dawned on us, but now we had to sit and think about it. It dawned on us, hold on, yes, you might not have the protection, but guess what, guys? it is a going concern. You're both VAT registered. So this is great news because now just sell it as a going concern. And instead of paying, I think it was like a 5 million rand deal, instead of paying all that transfer duty that you would typically pay, just buy it as a going concern and pay no transfer duty. Sure, you don't get the protection of the Alienation of Land Act. So you don't get that whole registration at the deeds office. And, you know, if the purchaser pays, the purchaser is entitled to this and this and this, sure. But you get that benefit and you are still protected contractually. So there's a lot of business sense when it comes to things like this. But when you merge the two together, you start like seeing that the waters do get a bit muddy.
Super muddy.
Yeah.
and I think, Bruno, I think it's one of those where when you actually sit and consult with the client, you will start drawing pictures and actually put it out. And the moment you start drafting the contract, then you're like, okay, cool. And everything fits together. So a hypothetical scenario to advise on what the best course of action or the best plan is like, what even? But I'm very glad I'm not the only one that can have the muddied water.
Thanks, Bruno. Thanks, Solna. I think we're quickly just going to move on to the next question then, which is a very similar question, but it's around how much does it cost to transfer a property? Now, this person had left, a deceased person had left a property to his spouse, and the estate, however, has no liquid funds in this estate, and the family doesn't want to sell the property. So first of all, how much does it cost to transfer a property? And secondly, how would you go about doing this if you didn't have the liquid funds to do so and didn't want to sell the property itself? I think we'll throw this one to Solna and then Bruno afterwards.
Cool.
Yes, so once again, one of those a lot of, I'm going to have to ask about 5 questions before I can answer this properly. So the one question is obviously, it feels like there must be a will. So theoretically, there will be an executor appointed. But the value of the estate, honestly, would be my first question. Because to not have any liquid assets in the estate doesn't necessarily mean it's a small estate. And so a small estate, Section 118, am I right, estate where you don't need to really go through the whole major big winding up process. What's the word I'm looking for?
It's administration.
Yeah, it's a simple administration of the estate, and it's not done. It can be done by a family member, because basically what you need to do is do a liquidation and distribution account, show what the estate has, show how it should be distributed. Whether there's a will or not doesn't change the thing too much, but it would be very difficult for, and I excuse my term, layman here, but for somebody that doesn't know law of succession to distribute funds in an interstate estate would be quite tricky, because how much goes to the spouse, how much goes to the spouse if they are married in community of property compared to married out of community of property. What do you do if there was an ANC involved? There's a lot of things in winding up a deceased estate that most people don't know. To be quite honest, I think most practicing attorneys, unless you specialize in estates, might not know. We studied this way back when, and there's some application through our practice, but not that much for most attorneys. And so that would be the first question, the value of the estate, because if there's an executor appointed and the master of the High Court has to oversee the estate, it's a very different ballgame. So on the one hand, I've seen estates lie for years and years and years and years, and especially a small estate where the family doesn't have any urgency to finalize the estate. It can lie for years, honestly, and the deceased estate remains the owner of the property. as long as all the family members are happy, they live like that, and Bobby's sort of your uncle, but like that weird distant uncle that nobody really knows. So it's not an ideal situation, and I would never recommend that. But in a situation where a family doesn't have the money to do the transfer, to save up for a few years and then do the transfer, and only then submit your L&D account to the master to finalize the estate, is not a crisis. Um, it's ideal, like I said, to finalize an estate as soon as possible. The reason for that is you don't want that niece that nobody remembers and nobody knows where she comes from to come out of the woodwork 5 years later and lay claim to the house. So for that reason, I would definitely say wind up as quickly as possible, but depending on the details in the estate. So remember, if the deceased and the spouse we're referring to were married, for instance, in community of property, it's actually not a full transfer. It's an endorsement and basically a 50% transfer fee there. So it's not expensive. And remember, you already sit with estate duty in a deceased estate, and at the same time, you might have to pay transfer duty as the party receiving it. If it's a donation, however, you're going to pay donations tax. And I think at this point, before I pass the transfer duty conversation again to you, Bruno, I'm sorry, that's just what I do tonight. You just get transfer duty. But I think what's important to appreciate in the question is the absolute crucial element in, as a property owner, to talk to your family members about what's going to happen when you pass away. Now, in some cultures, it's much easier to talk about it. I know Afrikaans people, I mean, this is what we talk about basically the whole time. Okay, so what's going to happen if you die? I kid you not, it's a known thing. Afrikaans people do this. If the grandmother, she gets to like her last little bit, people walk around with stickers with their names on. I kid you not. This is a known thing. Dit sorry, Afrikaanse mense, ek praat uit, maar sorry, I had to say that in Afrikaans and nobody else knows. But but that's a thing. In other cultures, you don't talk about death because, I mean, you know, that's bad. We don't talk about it. But it's, I think, middle ground, maybe between the stickers on the granny doesn't look so lucky anymore and the sticker element to let's never talk about it. You need to find middle ground, because succession and the law of succession and estate duty and all those things can really end up ripping a family apart. And you don't want to do that. So have the awkward conversation. Ideally, you want to get to a place of seamless succession. And that's what I always help my clients with, to put the properties in companies, already have a will dealing with how the directorship and shareholding will pass. Ideally, have the shares of the companies issued to a family trust, so that there is seamless succession without any transfer duty, without any estate duty. So for this particular viewer, Bruno will explain exactly how much you're going to pay for that transfer. But for everybody else, while you are still here, please, please, please take a deep breath and have the family sit around and talk about how you're going to deal with life if one of the family members should pass away. It's not a fun topic, but it's a crucial topic.
So I think, so there's definitely two conversations here, and I think both these conversations merit like a level of attention. So obviously this viewer's question is quite unfortunate, and there's a lot of gaps here, which does make it difficult to answer. And the second portion of the discussion that needs to be had is just planning ahead, because after this discussion, you know, it should really get people thinking, like, how do I avoid a situation like this from happening? And we deal with quite a lot of this, especially the structuring and the planning and things like that. And the reality is that people are buying, people are selling properties, they're investing, they're running businesses, but there's a lot that they don't take into account. And not only does this sometimes just cause extra costs, but without realizing it actually cause bigger headaches. The family members go under stress. Now, remember, you've passed away.
That's
So-
your family member trying to claim your pots right now, is it not?
He's like, wow, Bruno looks a little stressed there. I'll take
It's
the
very loud. She's
whiskey.
very small and it's very loud. Yeah, so that realization and that stress that causes families it is a component that people don't often take into account. I mean, because we speak about the financial implications of actually dealing with your estate properly, and this is all about efficiency and saving on long-term taxes, and you're gaining on short-term taxes and asset protection, and intergenerational transfers. I mean, just focus on stress. Now, in this particular instance, what Silna said is you have an estate that's not liquid. Remember, the executive of the estate only has so much to work with. And in a very simplistic example, if you have an estate that has one property in it and it's worth R1 million, right? Now, I'm assuming in this instance that the property is paid off, because if it's not paid off, that's another conversation altogether. So let's assume that it's R1 million property and it's 100% paid off, but there's nothing else. What happens? The reality is that the executor can only work with that R1 million that they have. There's no actual cash anywhere else, and there's going to be no cash anywhere else. So it's not even a question of, oh, I need to bridge money so I can sell the property, but when I get the proceeds, I can pay that money back. There is no money. That property needs to get transferred, but the bad news is it's not just about the transfer of the property. What about everything else in this estate? You still need to pay the executor's fees. You still need to pay estate duty, presumably. If it's R1 million property and that's it, then it's okay, because you have the 3.5 million rand rebate at the beginning of that. So certain things you might have to pay, certain things you might not have to pay. It depends on values of estate. But if there's no money, even small little expenses like advertising, fees, those are all going to be payable. So from a planning perspective, moving on to the second point of the discussion, if you are going to insist on not listening to us and having things in your personal name and doing all of that, then at least get underwritten, right? There's insurance policies for stuff, for winding up costs, where you can basically say, great, when I pass away, whatever shortfall exists, the insurance company will cover me. It's extra expensive. So again, it would probably be wiser to listen to us, but whatever. You don't want to do that. The answer does lie in insurance or having liquid assets. So if you've got money parked in your bank account and you figure that's going to be enough to cover a whole range of things, because now the property has to be transferred. If there's a bond, somebody's going to need to either take out a new bond for that, and they're going to need to cover the bank so that this can go into their name. So that's now something to consider, and goes back to Silna's question: how are they married? How was that structured? Because if it's now a full-out transfer with a bond, the bank's going to want their money first. So where's that money going to come from? Does the person that's getting the property have sufficient affordability to be able to get finance? The person would need to afford to pay transfer duty either. They need to be able to pay transfer costs. So all of these need to come from the pocket of the person inheriting the property. So that's already now a concern. From the estate side, questions arise like, is there capital gains involved in this? So if there's a couple of properties they've appreciated over the years, and now SARS comes knocking on their door going, well, we actually need X amount, so you need to sell off these properties because it appreciated by whatever 500,000 rand, and we get capital gains off that. And again, there's rules from a tax perspective. Is it your residence? Isn't it your residence? But guys, be careful with this. So to answer this current viewer, it sounds to me, I almost get the feeling it's going to go to your spouse, but it was probably the residential house. I don't think that there's a co-ownership here, because if there is, Silna pointed out, then it is an endorsement. Not sure about the bond, but that is something to look out for. If there are costs that the estate needs to cover, my suggestion is whoever's going to inherit the property gets those together, undertakes to pay to the estate, and then takes the property. Otherwise, the estate won't have a choice but to sell whatever portion of the property belongs to the estate, raise the money, and then actually be able to defray the costs of administration.
Sure. Thanks, Bruno. Thank you, Silna, for that. I just have a question. It's a burning question. Now that Port Elizabeth's name is changed to Gqeberha, do we have to call the Queen Gqeberha? Is this the change that's going to happen as well?
I love the new themes we have these days. Thanks, Chris. If you told me in advance, I would have been wearing a crown tonight. I'm always keen for an excuse to wear a crown.
And a robe.
Shane, speaking of robe, my daughter has to go to school tomorrow with a robe because they have to dress up like what they want to be when they grow up. And unfortunately, if your mother is a lawyer, the statistical chance of you going to school with a bib and a robe is pretty high. And she looks so cute, but that robe is about 79 times too big for her. So I'm glad we didn't have to wear those robes, but I'll totally wear a purple queen robe and a crown.
Okay, let's quickly move on to the last question here, which is, it's actually quite interesting. It's a municipality overbuilds me for water. And I discovered that, look, at that period when the bill came through, no one had occupied my premises. So this bill, I know for a fact, is incorrect. Now, I've been unable to contact or reach the municipality to raise my concerns. So if I just leave the situation, I mean, it's not my bill at the end of the day. If I just leave it based on the error, what are the possible consequences that I might face? And secondly, how do I go about solving this? How do I get out of it? So I think let's again start with Silna, and then we'll throw it over to Bruno.
So I think this is a question that actually happens quite often. And I think from our reactions on that, but you struggle to reach the municipality. Yeah. I think everybody, if you couldn't read Bruno and my face on that one, there's, go read Blink. But so it's a thing, and it's a problem. And it's a problem we unfortunately see quite often. And the thing is, now I know for a fact what COJ's bylaws says, and I do suspect it's quite similar in all municipalities, but I am under correction on the other municipalities. But the rule is, as long as there's a dispute around your utility bill, a filed actual dispute with a reference number, the municipality can't just come and disconnect your supply. I have been successful with multiple urgent applications against COJ. This is why I know the bylaw on this one specifically, where they disconnect utility supply due to non-payment. The client says, but there's like a thread of emails for days. There's 1.5 million reference numbers. They're not coming back to me to resolve the issue. I've made it clear, and here's my proof that I've tried to resolve this matter. Then you're successful in an urgent application without even, skipping a beat on it, because the court is just going to say, guys, but there's a dispute here. To just not pay and not raise the dispute raises a major problem, because the COJ will issue a summons. And once you defend that, to now try and explain, but there's a dispute, they might even on a brave judge, and if you can't show your case properly in your plea and then affidavit to your summary judgment application, defense to summary judgment application, the municipality could very well be successful in some instances in summary judgment, so that won't even allow you to go on trial. Where if you have proved that you've raised a dispute and the municipality simply ignored you, they won't be able to be successful on summary judgment. And in that process, you probably will get their attention to resolve the issue. I do believe the case is quite similar for all municipalities, and most municipalities' bylaws does allow specifically for a dispute process. So the answer is never to sit back and say this is not a me problem. Even, and I just can't, let a conversation just go around everything except throwing in some rentals just for funsies. So even in the TPN leaseback, the residential leaseback, we make specific provision for the obligation on the tenant to take photos of the meter readings. So if the supply is directly from the municipality, now any municipality I'm talking about here, if they don't take photos on a monthly basis, so you can track as the tenant now, not the owner of the property, the tenant can track if the meter readings sort of look normal. So if you usually have this amount of water or electricity consumption and suddenly it's like, whoa, there's a leak or there's something. If the tenant doesn't do that, we place that obligation on the tenant to then be responsible should the municipality come down like a ton of bricks on the owner. And the reason why we do that is the person at the property would be the only one knowing if the meter readings are sort of okay or not, because you're the one using the utilities. If you have, 10 fish tanks that needs water changes on a twice a week basis, you're going to use more water, but you're going to know about it. The person that showers at the gym every day, you're going to know that suddenly you can't use this much water. You are using the utilities. So you're the one that knows. And if you do not raise the dispute quick enough, it can blow up in your face properly, which is why we try to protect the landlord against that blow up. So the reason why I'm saying that is if you don't raise a dispute and you don't raise the dispute within a reasonable time period, it's not defined what that is, but I mean, 6 months is not a reasonable time period. You can give it a month and you're like, let's see if they find their own mistake. Okay, maybe 2, maybe 3, but if you see still by month 3, there's some of the other disaster on your account, the court is going to frown on you on trying to explain why it took you this long to raise a dispute.
So that pretty much covered most of it. My experiences, dispute perspectives, absolutely right. We had a couple of buildings where we had to go in, we lodged disputes, they disconnected anyway, total justification to go to court and ask for reconnection because there was a valid dispute that was lodged. It was funny, interpretation of valid disputes in those instances. If memory serves, it was sufficient for a letter to be delivered to the municipality and stamped. And the issue that we have with our municipalities is you can deliver as much as you want and you can get as much as you want stamped. It's meaningless, right? So the flip side of this, and this actually happened to me, right, personally, when, well, I've never really had faith, but I think in this instance, I thought, you know what, let me actually try. So there was a massive increase. There wasn't a water leak, and all of a sudden, I think they like doubled or tripled. So I paid everything else, and I was like, no, not paying for water. And I sent off a dispute going, I'm not paying for water. Please correct this. Something's definitely wrong here. And it doesn't look like there's a dispute. You just got everything wrong. In fact, if I'm not mistaken, they just blatantly got the meter reading wrong. And they just took a meter reading that just was non-existent, right? It wasn't there. And sent the dispute. Now, the problem with the municipality is amounts that are owed. They don't care what amount is owed. If it's owed, they go and disconnect services, right? So here they come and they disconnect services. So practically speaking, the problem that you experience is whether lodging a dispute entitles you to some kind of stay of process versus whether they'll actually stay the process are two very different things. No one wants to go to court on an urgent basis. So even though we've succeeded, it was still a day or two without electricity, the legal costs relating to court, and just the displeasure of having to actually deal with the municipality on the other side, which don't listen to you, don't receive phone calls until an attorney is approached. And this is the one time people are actually very glad that there's been an attorney, that there's an attorney on the other side. Because believe it or not, it's the only way that there is an actual interaction most of the time. But yeah, on Silma's point, so lodge a dispute, just be careful, because there is case law that says, for starters, if you have a dispute regarding electricity, that does not mean that you shouldn't pay property rates. So don't get ballsy and decide to not pay anything to the municipality. That's going to be a problem. So you don't pay what's in dispute, and everything else you still need to pay, first of all. Second of all, practically speaking, it might not be a bad idea to just pay everything in dispute later, because of my experience, which landed up with having to go to court and force them to reconnect. No one wants to do that, right? So just be careful from a practical perspective. Then I think that pretty much covers it. Tenants, I agree completely. Get them to be responsible. Fix their payments to the actual consumption, and that does give them that level of responsibility. It's a good idea anyway, because ultimately you don't want to fix a payment of water and lights and let them just go around having nice long showers and you fitting the bill. So yeah, it's quite intuitive to actually do that. Consequences of not paying. So let's say you don't raise a dispute and you simply just don't pay. Well, I mean, what do you think is going to happen? They, for all intents and purposes, they think that you owe them money. So what would you do if somebody doesn't pay you and they're supposed to and they don't say anything? So I mean, to a certain degree, let's apply a level of logic. They're going to be angry with you. They're going to want to collect their money. They're going to take steps. If they take steps, that's legal costs, that's interest. All of this then accumulates. Trying to then get that discount, it's going to be a disaster. And remember, they've got a charge over the property if it's in your name. So they can go off and try sell your property, provided they've obviously got a summons and a judgment and attached. So they can go after your property and sell it like almost a bank can off the bat. So just be careful. You've got a lot of risk there. And if you then try to sell your property to somebody else and there's a debt due to the municipality, you're going to need to pay that debt. So they've got all the security in the world. They're pretty much, like from a security perspective, they're quite high up. You're not going to easily get around them. Rather see the issue, get a rates consultant. We work with tons of them, appoint them. They go in there. I don't know how they do it, but they charge you on savings and they get more off than what you actually asked them to get off. And that's great. And you pay them a portion of it. You get a great savings and you carry on with your life. And that's the best advice I can give.
I think it's brilliant advice, because I don't know how people get around these kind of disputes without rates consultants. And I think I think you make a very valid point. I think the only thing I want to throw in, and Chris, then I'll keep quiet, I promise. But the only thing I want to throw in, Bruno, is people have the perception that if you are not in the wrong on your version or in your mind or in your reality, that a judgment must just disappear. So say, for instance, you have a rental property and there's a dispute, but it's sort of, you feel it's sort of the tenant's problem. So someone not paying anything, like Bruno said, not rates and taxes, nothing. Summons gets served on a domicile address, which is the property where the tenant stays. Tenant doesn't have an idea what's going on. He receives a summons and he's like, this is not my name. Doesn't register, it's the landlord's name. Chucks it away. That is a valid form of service in that particular context. And they obtain a default judgment against you. That judgment sits, and you will have to have it rescinded. But now, to have a judgment rescinded, there's a lot of very specific rules to it. You can't go to court and say, rescind my judgment because I didn't know about it. You have to show that you still have a valid defense. So you might have still been successful in defending your matter. So if you haven't paid a thing and you accidentally miss the summons and you end up with a judgment against your name, it's not a hit, undo button. It's an actual court process, and the court may refuse that rescission on the basis that you might not have a defense to a portion of the claim. And still, even if you are successful with that rescission, then you're going to have to throw it back to a trial process. So never, ever, ever just let something sit. The only thing ostriches are good for is a nice fillet steak without any cholesterol on you. So I think that's something quite important to keep in mind. Never just ignore something; it won't just go away.
Oh, thanks, Solna. Thanks, Bruno, for that advice. So there we go. Don't just bury your hand in the sand. Don't bury your head in the sand and hope that things will just happen for you. It won't. But thank you, everybody. Thanks, Bruno. Thanks, Solna, for such an informative episode of the Wednesday webinar. Thank you to our viewers for joining us again. And please, we urge you, post your questions in the group, post them to us, and we will definitely get back to you. I hope that you all have a great week coming up. And yeah, see you next week. Bye, Bruno. Bye, Solna.
See you next week.
Thanks. Bye.
Bye-bye.